Well, hello everyone, and welcome back to AJ102 Introduction to Criminal Justice. My name is Tony Farrar, and of course, I am your instructor for this semester. So, this week's lecture is going to be on Chapter 8, where we're going to take a look at police and the rule of law. A lot of content, so we might go a little bit over with each section of this lecture. So, let's go ahead and just jump right in because, again, we have so much to cover. So, some of the objectives: we want to be able to define a search and an arrest, distinguish between a search and an arrest warrant, and then talk about when do we need these warrants. Also recognize that there are 3 requirements that have to be met before the judge will actually issue that search warrant to you. Explain the rules about serving warrants. We'll talk about different types of warrantless searches and arrests, meaning that we don't need a warrant for those. We'll focus a little bit on the Miranda decision, talk about lineups and identifying suspects, and then we'll finish up the chapter with a short discussion on the exclusionary rule and some of the exceptions. So again, let's go ahead and jump right into it. So, although police want a free hand to apprehend criminals, the Constitution's Fourth Amendment restricts police activities in several different respects. It dictates what force can be used, what requirements are for search warrants, and where and how police can look for and even identify suspects. Now, when police want to also interrogate a suspect, they have to remember and honor the Fifth Amendment's prohibition against forcing people to incriminate themselves. So again, a lot of considerations. But once a crime has been committed and that investigation has started, the police are going to use different types of means, if you will, to collect evidence needed for that prosecution. And as they do this, several questions kind of start to come to light. So let's take a look at those. One could be, should surveillance techniques need to be employed to obtain information? And how can information be gathered to support a warrant if I need one? If the suspect was driving a car, can the car be searched without a warrant? Can we tap somebody's phone or record their conversations? Is there reasonable suspicion to justify stopping and frisking someone? What constitutes an appropriate interrogation? Can a legal arrest be made, and can witnesses be brought in to identify a suspect? Again, a lot of questions start to formulate in the officer or the investigator's mind. Now, the Supreme Court of the United States has taken a very active role in answering most of these questions, because its primary concern has been to balance the law enforcement officer's need for a free hand, if you will, to investigate crimes with that of the citizen's constitutional right to be free from illegal searches and interrogations. So in some instances, the Supreme Court has expanded police power a little bit. And in other cases, the Supreme Court has basically restricted some of that police power and subsequently some police operations. So a lot of things to kind of think about. Now, again, when it comes to search and seizure, some of the key elements of police investigations are the search for incriminating evidence, the seizure of that evidence, and then the use of that evidence during that upcoming criminal trial. Now, the Fourth Amendment protects criminal suspects against unreasonable searches and seizures by placing limitations on what law enforcement can do with their efforts to catch lawbreakers and collect evidence. And, we won't read the Fourth Amendment. I think I have a slide on it here. But here it is. So the Fourth Amendment talks about the right of the people to be secure in their houses, persons, papers, effects, etc. And take note that it doesn't say against searches or all searches or some. It says unreasonable those that are deemed to be unreasonable, and that those searches or applications for a search warrant, if you will, can only be done if you have probable cause. So, kind of in a nutshell, the Fourth Amendment forbids the unreasonable search and seizure. The two main cases, as it, kind of revolves around not only the exclusionary rule, but, the unreasonable search and seizure would be the Weeks versus United States and Mapp versus Ohio case. It does require probable cause, just like the judge won't issue a warrant without probable cause. And we'll talk a little bit more about that in just a few minutes. So, how then do we kind of look at this? Well, some key elements, again, of police investigations are the search for incriminating evidence and the seizure of the evidence, etc. So we need to know that there are two important parts to that Fourth Amendment. Okay, the first is called the reasonableness clause, and the second is called the warrant clause. So the reasonableness clause, it stops at shall not be violated. So it simply states that searches and seizures must be reasonable. And now you're probably asking in your mind, well, dude, what is reasonable? Well, we'll talk about that in a little bit. And then the warrant part of the clause starts at, and no warrants shall issue. So this part of the Fourth Amendment lists the warrant requirements. So these two Fourth Amendment parts are not necessarily connected. For the most part, they are, but they aren't. And a search can be reasonable without a warrant, but if a warrant is required, it has to reach specific requirements. So hopefully that kind of makes sense. So now, what then is a search? So the dictionary definition of a search is pretty straightforward. It means to look for something. You ever lost your keys? You can't find your keys, where you left them or whatever. With me, it's I set my coffee cup down and I can't remember where I put it. So I kind of search for it. So I'm looking for something. Now, in search and seizure context, however, the search has a very distinct meaning. So it is a government actor, could be law enforcement officer, etc. So a government actor's infringement on a person's reasonable expectation of privacy. Now, typically, a Fourth Amendment search occurs only when a government actor, officer, infringes on that person's reasonable expectation of privacy. And that government actor, again, most often is a police officer. So it's fair to say that a police officer's actions almost always trigger the Fourth Amendment, which is why it's so important for us to understand the dynamics and the content of and the context of that Fourth Amendment. So again, kind of staying with the search. So we know what a search is. Well, what isn't a search then? So we already talked about what a search is. So what's not a search according to the Fourth Amendment? Well, abandoned property. If a person abandons property, that person cannot assert privacy over it, right? And a really interesting case, California versus Greenwood in 1988, shows that basically putting your trash cans down to the curb, okay, even the curb right here, you've kind of shown that it's going to be discarded, and it could be looked through by people coming by looking through for cans or anything else. So you don't really have a right to privacy anymore when it's down by the curb. Now, if these cans were up inside of your, all the way up in the top of your driveway, it's a little bit different. But once they're brought down to the curb, this case, California Greenwood, kind of says, hey, it appears that this is garbage. It's going to be picked up. Anybody else could look through it as well. So therefore, it's kind of fair game. Another example could be dropping a backpack while running, right? If you throw something while you're running, then you've basically abandoned that right to privacy. So abandonment would be one of those. Next would be open fields. So again, we're talking about what's not a search. So in Oliver versus United States in 1984, the U.S. Supreme Court distinguished between the privacy granted to people in their homes or adjacent grounds and fields. And the technical term for that is called curtilage. So an open field would be unoccupied or undeveloped real property outside of the curtilage of a person's home. And you can say curtilage if you want to pronounce it like that. That's fine. So again, the curtilage are grounds or fields that are attached to somebody's home. And a good way to look at it is by a photo, right? It's always easier to see things. So, here you see the curtilage evidence is not admissible, meaning there's a right to privacy inside this little fence, even across here, because there's this imaginary line, if you will. But now way outside in this open field, if you will, even if there's a sign, but way outside here, it would be admissible because there's no expectation of privacy out there, but within this fenced curtilage area of your home, there actually would be. So hopefully that picture kind of helps the concept of what we're talking about. So again, the curtilage is the grounds or fields, attached to that particular house. Okay, so what else is not a search? Well, interestingly enough, flyovers. So in California versus Suriola in 1986, the police received a tip that marijuana was being grown in a backyard, and the yard was surrounded by fences, one of which was 10 feet tall. So you can't climb over the fence because you're invading the curtilage, right? Okay, but here the officers flew over the yard in a private plane 1,000 feet up to confirm the grow and then used this to get a search warrant. And in this particular case, the U.S. Supreme Court held that the officers did not violate the defendant's rights under the Fourth Amendment. So, kind of interesting. And this holding later on was expanded in a case called Florida versus Riley, when the court ruled that the police do not need a search warrant to conduct even low altitude helicopter searches of private property. So a little bit kind of loosening of the reins there. So California versus Suriola. And this would be an example when you fly over the top here and you can see the marijuana grow inside of all of the forest. You wouldn't be able to see this from down below at eye level, right? But you can certainly see how the illegal grow is weaved in between those trees right there. Okay, so we've looked at a couple of examples of what would not be a search, if you will. So now let's talk about an arrest. So the Fourth Amendment does not mention arrests, but it does mention seizure. So an arrest, in essence, is a seizure under the Fourth Amendment. And an arrest is one of the most common types of seizures. Some other actions like field interrogations, those are also considered seizures in some fashion sometimes. But here we're going to kind of concern ourselves with an arrest. So an arrest occurs when a police officer takes a person into custody or deprives that person of their freedom for having allegedly committed a criminal offense. Now, the police stop many people each day for a variety of reasons. So the time when an arrest occurs may really be kind of hard to pinpoint. And some people are stopped for short periods of questioning, and others are informally detained and released, and still others are formally placed under arrest. However, a legal arrest occurs when some of the following things exist, okay? So number one, the police officer believes that sufficient legal evidence which would be probable cause, exists that a crime is being committed or has been committed and intends to restrain that person. Next, the police officer deprives that person of their freedom. And then next would be the suspect believes that he or she is in the custody of the police and cannot voluntarily leave. So those are, basically saying a legal arrest occurs when these following things actually exist. And we talked about, you've heard about probable cause a couple of times, and here are a couple of what we call levels of required proof or burden of proof. And some of these are used in civil cases and some are in criminal cases. Reasonable suspicion is basically, this is the amount of evidence that an officer needs to stop someone, even frisk them, according to the Terry versus Ohio case. But you need probable cause to arrest or do a thorough search on someone. And then you go up here to the top, beyond a reasonable doubt. This is evidence beyond a reasonable doubt. This is what you need to convict somebody. And some other states use preponderance or clear and convincing, and then some of these are also used in civil cases. So let's define an arrest a little bit more. In Draper versus United States, the Supreme Court states that probable cause exists where facts and circumstances within their, meaning the officer's knowledge, and of which they had reasonable, trustworthy information are sufficient to warrant a man or woman of reasonable caution in belief that an offense has or being committed. So this is kind of talks about probable cause, meaning like, well, what is it, right? Reasonable grounds for presuming guilt, facts that lead a person of ordinary care and prudence to believe and conscientiously entertain an honest and strong suspicion that this person is guilty of a crime. So here again, we're trying to kind of give you more elements of probable cause. Okay, so stated another way, probable cause requires that a police officer objectively conclude based on reasonable, reliable facts that a crime has been committed and that the person being arrested committed the crime. And that's the Carroll versus United States. And the Supreme Court also stressed that this is going to be based on common sense, a practical evaluation of all the facts, the totality of all of those facts, because it can't be reduced to just a set of rules or some mathematical formula. There's more to it. This probable cause thing, there's more to it. So this is how the Supreme Court basically decides, hey, did the officer have probable cause or not? And they're going to look at these different factors. And then finally, kind of just to go a little bit further, because I know it's tough to get, probable cause in the Smith versus U.S. case. The sum total of layers of information. So all of the facts, all that stuff, and then the synthesis, meaning, kind of what the police hear, know, and observe as trained officers. Reasonable grounds for presuming guilt. And probable cause can be based on observations or expertise, some circumstantial factors, and also information that's given to officers. And again, here's another burden of proof, but this is a pyramid compared to the other one. So this helps establish probable cause. Okay, so enough on the probable cause thing. I think you got it, right? But I wanted to make sure that you kind of get all of the different facts. All right, so now we're going to talk a little bit about search warrants and then arrest warrants. So we know there's these two types. So there are two varieties of warrants: search warrant and arrest warrant. Now, a search warrant is an order issued by a judge directing officers to conduct a search of a specific premises, location, place, for specific objects. Does that kind of make sense? And the Fourth Amendment does not necessitate warrants for all searches and all arrests. And we'll talk about that in a minute. Okay. An arrest warrant, and we'll get to this again, is an order issued by a judge directing the officers to arrest a person. Okay. And so there's kind of the difference, if you will. But we're going to stay with the search warrant. Okay. Well, there's the arrest warrant. All right. So we already kind of covered that. So warrants now, when you talk about the Fourth Amendment again doesn't necessitate warrants for all searches and arrests. In some situations, however, warrants are necessary. So they are required in a couple of key reasons, if you will. First would be arrests and searches in private homes or on specific types of private property. And second would be arrests for minor offenses committed out of the view of the arresting officer. And kind of a little unique on that one. So if something is committed out of the view of the arresting officer, what happens is there's what we call an in-presence requirement. So a police officer cannot arrest someone for a misdemeanor unless they actually see it occur. Although there are a couple of exceptions that we're going to consider. One could be a DUI collision. But an in-presence requirement basically says that an officer can't arrest someone for a misdemeanor unless they see it occur. So to make an arrest for a crime that the officer didn't see, they go get an arrest warrant. So does that kind of make sense? They spell out the information in an affidavit, and we'll talk about that more. They bring it to the judge signs it, they get the arrest warrant, they go back and they arrest the person. So those are the two factors, if you will. Okay, so hopefully you're still with me. Now, we talked about 3 requirements that must be met before a warrant can be secured. And this is an actual search warrant, and the areas of black you see are called redaction. It's critical information that we can't show you. Might be someone's name or date of birth or something similar. So we've kept the warrant, all of the information, but we've redacted some of that other stuff that you're not supposed to see. But I wanted you to see what an actual warrant looks like. But there are 3 requirements that have to be met or satisfied before a warrant can be issued. And those are probable cause, because remember, it's in the Fourth Amendment. We read that, right? A neutral and detached judge or magistrate. And then the third one, which is called particularity. And that's kind of focused on what the place is that you're going to search. And we'll talk about that. So we've talked a lot about probable cause. So a warrant can't be used unless it's based on probable cause, which is typically defined as, and we've defined it already, but reasonable belief based on fact or facts that a crime has been committed and that particular person, place, or object to be searched or seized is linked to that crime with a reasonable degree of certainty. Now, under normal circumstances, a search warrant cannot be obtained unless the request for it has basically been supported by facts, supplied under oath by the officer, stating that there are sufficient grounds, if you will, to convince the court that a crime has been or is being committed at a certain location. So, kind of in a nutshell, to establish probable cause, the police must provide the judge or magistrate with information in the form of a written affidavit, which report either their own observations of or those of private citizens or police undercover informants. And if the judge believes that the information is sufficient, and it establishes probable cause to conduct the search, then he or she will issue the warrant. And note that although the suspect is not present when the warrant is issued and therefore cannot contest its issuance, he can later challenge the validity of the warrant at trial. But basically when you go to get a warrant signed, it's just you and the judge, or you, your partner, and the judge. So to establish probable cause again, and I have a kind of a picture of it, the police must provide the judge with this written affidavit. And you can see here, here's the affidavit, right? And there are several sources of information that the officers can use to establish probable cause. It can be firsthand knowledge, meaning they saw it happen, they witnessed it. It could be from an informant, anonymous tips, even telephone tips. Because remember, it's all these facts gathered together that establish that probable cause. Okay? And some other things that help establish, I call it PC, or probable cause, could be the suspect's activity, attempting to conceal themselves, running, like flight, they're leaving, the manner of dress, the location, the time of day, their prior criminal record, number of suspects, important information, suspect's appearance, pattern of activity, or facts gained by officers. So all of these things are things that can help you establish probable cause. Okay? So hopefully this kind of makes sense. Direct observations are typically kind of the best, and an officer may rely on his or her five senses, if you will, to develop that probable cause. And it could be sight, sound, smell, touch, or even taste. And so it could be, I see the gun. So what you see. It could be sound. It could be gunshots. It could be other types of sound. It could be what you smell, if you will. It could be the feel of something. So these are like little heroin balloons that are packaged in a larger plastic baggie. And if you're a narcotics detective, if you were to feel these in someone's pocket, the way that they feel kind of weird and the rubbery sense, you could testify as an expert that you believed that they were heroin balloons. So these are things, and again, help establish this PC. Okay, so neutral and detached magistrate. So remember, this is number 2 of the 3. We have the PC, the probable cause. Now we're going to move on to this. So warrants can be issued only by a neutral and detached magistrate. Any judge, however, typically is considered neutral and detached. And, requiring that a judge sign off on a warrant brings that element of objectivity to the criminal justice process. It serves as a check on the police officer's decision concerning who should be arrested or searched, right? So that kind of makes sense. So when that judge signs that, or they read the warrant, that's a third party that's kind of deciding whether or not you have met the burden of probable cause. Because if you wrote the warrant or you wrote the affidavit, you're probably going to think, hey, I'm a great writer, so it's cool. This is great. I have all kinds of PC. But you may not. So the judge, as the neutral third party, is better apt to make that decision. Now, before a warrant is going to be issued, a police officer must offer sworn testimony that all the facts on which the request for the search warrant is made are trustworthy and true. So basically, when you fill out that affidavit, you're going to have to sign it in the judge's presence, stating that everything is true, but also in the judge's chambers, you're going to raise your right hand and they're going to ask you, Officer so-and-so, is everything within this warrant true and correct, so help you God? And you're going to have to say, yes, it is, Your Honor, and then etc. That's why when you're a witness in a case or an officer, etc., in a trial, and you get up and you stand in front of everybody and they say, raise your right hand, you put your hand up and they go, do you swear to tell the truth, the whole truth, nothing but the truth, so help you God? And you go, yes, I do. That's because if you lie, then you're committing perjury. So it's the same principle as it relates to a search warrant. You're going to raise your right hand and say, is everything within the search warrant affidavit true and correct to your best of your ability? So help you God, yes, Your Honor, I do. And then you sign and he signs or she signs, etc. So the same system for a warrant or for even testifying in court. So that's the neutral part. Okay. And then the third part is that particularity part. So the Fourth Amendment, if you remember, states in part that warrants must particularly describe the place to be searched and the persons or things to be seized. Otherwise, if they just signed a warrant, it would be a general warrant, meaning, and that's back in the days of early English law where you'd get a general warrant signed, which means you could search for anything. Well, they don't want you to go on a fishing expedition. They want you to state where you're going and what you're looking for. Oh, and who you're looking for. So you can see, I request a search warrant to be issued for this address. And then you describe it. Off-white stucco exterior. So this way they know that you've done your homework and this is the place. Here's the persons to be searched. Okay? The vehicle, if any, to be searched. So this is what they call the particularity part of the Fourth Amendment, or as it relates to search warrants. So this requirement, again, was included in the Fourth Amendment to counteract the use of general warrants, like I said, used against the colonists by the English crown. And you know, it's concerned with specifically naming the items to be seized pursuant to a search, or specifically naming the person to be arrested pursuant to an arrest warrant. Now, with all of that said, okay, it doesn't mean that if you go into a house on a search warrant and you're lawfully there as the result of that warrant and you see other illegal items, it doesn't mean that you can't seize them, because you can. But at the very beginning, again, they want you to describe what it is you're looking for and where you're looking for, because that particularity requirement is designed to curtail potential abuse that may result from an officer being allowed to conduct a search with basically unbridled discretion, meaning like, I'm just going to go there and search through all your stuff, and if I find something, great, and if I don't, well, fine. Okay, so that's the rationale for that. Now on page 300 in your textbook at the bottom, it talks about the 3 warrant requirements: that probable cause, the neutral and detached judge, and then that particularity requirement. Okay, so now we're going to talk a little bit about serving the actual warrant, right? Because at some point after you get all this stuff done, you're going to have to serve the warrant. So there are procedural steps in serving the warrant. The first is basically, and these are they're mostly the same for each type of warrant, but they include knock and notice or knock and announce. And in general, when a warrant is served, officers basically have to announce, knock on the door and announce their presence. And officers must announce their authority with their intentions. So when it is likely that an announcement would threaten officer safety, that knock and announce rule can be waived by the judge, right? So if they're manufacturing machine guns in this place and you knocking on the door might give the people time to arm themselves, the judge can waive the knock and announce part. But that's the rationale, the reason for the knock and announce, to give somebody basically reasonable time to come and open the door. Next would be keep property damage to a minimum. It may be necessary for officers to forcibly enter that location if the door is locked or barricaded. And likewise, it might be necessary to damage a person's property when searching for items in the warrant. Either case, the standard is what they call shock the conscience. So if the property damage shocks the conscience of the court, officers could be held liable for those damages. So keep property damage to a minimum. Next, use appropriate force. It may be necessary for officers to use force during the service of either an arrest or a search warrant. An arrestee might resist, or the person whose property is searched could decide to either flee or even attack law enforcement. In both cases, the standard governing deadly and non-deadly forces apply. And we talked about some of those in the previous chapter. So, appropriate force. Next would be paying attention to the time constraints. So, most search warrants require daytime service. The warrant may also limit the amount of time officers can take to search for the evidence. In most jurisdictions, these requirements can be voided if officers obtain warrants that permit night service or contain other special instructions. So you could get a no-knock warrant, which means that you're not going to do the knock and announce because of danger. And you could get a night service warrant because you want to catch somebody because they're so dangerous, chances are they might be asleep at night, and you feel it's safer to get them, maybe you catch them in their bed sleeping after you force entry into their house. So, and then the last thing is your search warrant is only good for 10 days. Okay, so after 10 days, you have to do what they call refresh, which means you have to get more information, go back to the judge, and then redo your search warrant. So you need to, if it goes past 10 days, it's called stale. So pay attention to the time constraints. Next, limit the scope and manner of the search. So the scope and manner of the search has to be reasonable in light of what you're looking for. All right. So if a search warrant authorizes police to look for stolen jewelry, then they can pretty much look anywhere, right? Because jewelry's small. Now, in contrast, if the warrant names, big screen TVs, then the police can't look in drawers, cabinets, or other small places unless they're looking for paperwork or something else that might be smaller that relates to the crime that they're investigating. And then finally, no reporters allowed. The Supreme Court has held that the police cannot bring members of the media along on the service of search warrants unless they are there to serve a legitimate law enforcement function, such as videotaping the execution of the warrant for training purposes. And we're talking about inside during the search. They can stand on the outside and videotape the entry into a location, but they can't videotape on the inside during the service of the warrant. Afterwards, they could be brought into the scene, if you will. Okay, but during the service, they can't. So again, these are some procedural steps. Okay, a couple more, and then we'll take our first break. We're going to talk now about, the warrantless searches again. Now, under normal circumstances, the police need to must obtain a warrant to conduct a search. However, over the years, the Supreme Court has kind of carved out some significant exceptions to the warrant requirement of the Fourth Amendment. And these include some of the following, not limited to, but they include these. So one might be what they call emergency circumstances, or stop and frisk, searches incident to lawful arrest, automobile searches, consent searches, searches based on plain view, or crimes committed in the officer's presence. So as we kind of back up and we look at some of these, circumstances, we'll take them all one at a time and we'll kind of go through them a little bit. And then again, like I said, we'll jump into probably our first break here shortly. So first would be what we call hot pursuit, meaning like the officers are, either chasing someone, or let's say they're involved in some kind of shootout with three suspects who run into a house. The police would be allowed to enter the premise without a warrant in order to find and arrest the suspects. So the warrantless search would be allowed because the police were in hot pursuit, if you will, of the suspects, and because failure to search could put citizens in danger, a condition that the courts typically view as some type of an emergency. Okay, and then there are a couple of other factors, but for lack of time, we're going to kind of just talk about hot pursuit as it relates to running from the police, etc. Next would be danger of escape, or flight, if you will. So if there's a possibility that the suspect will escape if the police have to take time to get a warrant, they may be able to dispense with the warrant requirement. So, for example, if police learn through an informant that a dangerous robbery suspect just entered an apartment complex, they may be able to enter the premise to find the suspect if they can't secure a warrant properly or obtain a warrant in time. So again, the courts are going to look at all the factors involved in that. Next would be, threats to evidence or destruction of evidence. So, if the police have probable cause to believe that a person is about to destroy critical evidence, like flushing drugs down the toilet, they can enter private property to seize the evidence without first getting a warrant. Now, once they get inside and secure that scene and have recovered the drugs from the toilet, etc., they are going to need a search warrant to search the rest of the location because they've already dealt with that threat of the destruction of evidence, right? But just initially, if they believe that the evidence is going to be destroyed, they can stop that by entering the location, but they're going to have to get a warrant after that. Threats to others or public safety. So if a suspect poses a risk to others, it can also be considered an emergency. An example could be a hostage situation. The police usually dispense with a warrant requirement and will enter property if it's safe in order to protect the lives of innocent people. Okay. Fires inside of a house. If the officers drive by and they see flames coming out of a residence like you see here, they can run into the location in order to protect those inside and to get people to safety. Okay, so they have the right to go in there and do that. So these public safety things are important. Okay, so this might actually be an okay time to kind of stop. So we're going to stop here and we'll pick up with the stop and frisk when we come back. So this will conclude part 1 of chapter 8, Police and the Rule of Law.